você sempre real. No céu, no mar, tô fechada com você. Não vou voltar, eu não quero nem saber.
Hi there, and welcome to Intangify. I'm your host, Matthew Asbell, and my guest today is Flavia Murad-Schaal. Flavia is a good friend of mine in Brazil and an attorney practicing there, though right now she's coming to us from Miami. And we have a really interesting show for you today because there's this song that's sweeping the nation in Brazil. Yeah, it was generated by AI. So let's begin. Flavia, can you tell me a little bit about what song this is?
Yeah, sure, Matthew. Thank you very much for this opportunity and moment we could be together. I'd like to explain what happened in Brazil this month. A Portuguese version of the song, The Fate of Ophelia, originally performed and co-written by Taylor Swift, went viral on social media and digital platforms in Brazil. The new version, titled Sina de Ofélia, was not recorded by artists. It appeared to involve AI totally. So it's totally digital. The track was generated by artificial intelligence, simulating the voice of Brazilian singers Luísa Sonza and Dilsinho, as if they were performing pagode. It's a Brazilian style adaptation of the original song. So the creator of the AI-generated track remains anonymous. We don't know who this guy is. And the technology used to generate the instrumental and synthetic voices was not disclosed. So the song was independently uploaded to platforms such as YouTube and briefly appeared on Spotify through unofficial profiles without any copyright credit or license. So this is very interesting how these guys could upload the song there. So none of the original right holder, Taylor Swift, the co-authors, anyone from the record label, so authorize the translation, adaptation, or distribution of the new version. So this new version in Portuguese language, is exactly the same lyrics as the English version. So they didn't change anything. They might have like Google Translator put in a prompt to generate this new track. So Luísa Sonza and Dilsinho, both Brazilian artists, did not consent either the use of their voices or names, so which were used to promote the songs in apparently a collaboration between them. But we know it's not true. It's totally fake. So it's all AI generated, let's say, music or song. This is what is very interesting on that. And it was a tremendous success during our summer. The parties and young people all celebrating. I heard this morning that this might be the music of the Carnival of this year. So after went viral dissemination, the track was removed from major platforms, though following copyright complaints. So people are moving.
So this was first brought to my attention over this weekend, and I assume that many of the audience based in the US are not hearing about this like they are in Brazil. I wanted to hear this track and found a version of it on YouTube with the video. You know, removing my IP lawyer hat for a moment, I have to say, as a fan or as a lover of music, wow, it is a good track. I mean, it's really entertaining. I like it better than the original. And that's really interesting, you know, like to hear this this AI generated track that I mean, the singing is really great. and the music, the pagode style in the background, it really goes. And I mean, I really like the original, and I really, really like the AI version. So it's not surprising. I mean, not that I'm necessarily the arbiter of taste in Brazil, but it's not surprising to me that it was such a big hit and is such a big hit in Brazil. What I heard, my wife, who's also Brazilian, mentioned to me what she had read, that it's so big that people who are going to the concerts of Luísa Sonza are requesting her to play it. Do you know anything about that?
I haven't heard of that, but I imagine she could be like playing with that because she posted in her social media account, she trying to, you know, repeat the experience with AI. So playing with it, not seriously like singing or earning any kind of financial gains with that, but she was like playing, just playing informally. I hope Taylor Swift is not upset. Maybe she is upset, actually.
That's what I'm told. I'm told that she's upset, and rightfully so. I mean, there are rights in these. So let's put our IP attorney hats on for a second, or maybe for longer than a second. But there are rights in these works. So, you know, traditionally, if I were to write a song and someone in Brazil were to take my song and do a version of it, the same melody and chord progression and same words just translated, I would have some rights over that. Is that the case in Brazil?
Oh, yeah, for sure. She has rights. Taylor has rights. And not only the copyright, but the everything that it's involved in the music production. So everyone involved has rights. And those rights were directly infringed. This is clear.
So the law does protect against something like this, at least in theory, except as you mentioned, they don't know what platform was used to create it or who created it.
Yeah.
So how do they sue this person?
For the moment, yes. We don't know who this person is. And maybe Taylor Swift is dealing with the platform directly. And since this is not like shown as the real person who owns the page of Suno, for example. I don't know if it was made for Suno, but let's suppose that it was. So Suno has to take down whatever was infringed because of the protection.
But it's pretty interesting, though, because this has been going on for a little while in Brazil, I understand. I was able to find it on YouTube, over the weekend, and YouTube has a stringent program to take down these sorts of types of copyright infringements. So I'm kind of curious why it's not really down everywhere and you can still find it.
Yeah, in Brazil, at least for the moment, because the law changed after Supreme Court, very large judgment, and it was published very recently. So the rule is that we have to have a court order to take down the illicit content. So Taylor Swift has to file the suit against the platform. So the platform will be compelled, will be obliged to take down the content. So this judgment changed everything. So they might be in a limbo, in the gray zone, whether you have to have an order or just the notice of takedown would be enough, would be sufficient. So I suppose they're struggling with that. If the Supreme Court order judgment and ruling is already in force, or they really need the previous ruling, which is take down after a court order. If Taylor Swift, I suppose, doesn't file the suit, she won't have this court order. And I believe she hasn't filed the suit yet.
It raises an issue, though, of sort of how these types of rights work internationally, because Taylor Swift is in the United States, right? She has United States copyrights, if that's what she's asserting here. And the YouTube pages that I found, I believe were on the .com website, not on a .br Brazilian website. So would she have to follow under Brazilian law because was done in Brazil or with a Brazilian artist?
I don't believe so, because the effects are global. So if if you have access in the United States, you can have the U.S. rules applied to this case.
So that brings me back to, I'm surprised that I found it on YouTube, in the United States, this weekend. But who knows what's going on? But it's really interesting. What I find really interesting about it is not solely about, hey, there's a copyright that's being infringed, and even cross border, that kind of thing happens, and usually there's recourse for it, as we've described. But it doesn't just involve copyrights. There's some other rights involved, including the rights of the artist whose voice was imitated and who's, I think they even have video, right?
The simulated use of Luísa Sonza's and Dilsinho's voices, combined with the association of their names, constitutes unauthorized exploitation of personal attributes protected under Brazilian constitutional and civil law. So I think it could be the right of publicity of U.S. law. So we call them as personal or personality rights in Brazil. Those are civil law concepts, exactly how it is in continental law countries, not common law countries such as it is in the U.S. and some other countries. So it could be an infringement of a personal right.
So is Luísa Sonza taking those actions, or do you know if she has taken those actions?
I don't think she's taking, because it took her, it was positive for her, because she became more and more famous because of this use. And since it went viral and everybody's talking about her, I think it's very convenient for her not to get involved in a lawsuit because of that. So I think she thought this might be treated as a joke instead of taking this seriously.
I think that's actually very interesting in a much broader perspective. We are being specialists in a particular area of law where we can see whether rights are violated or not and what actions we could take. It's not uncommon for us to need to look at things from a different perspective. What's the public view of what it is I'm doing? What's the damage? Is it appropriate for me to take a legal action? Law is basically just one tool in a whole set of tools that you might be able to take, might be able to utilize when things like this happen. And I think, it's interesting because, the news outlets and the public generally jumps to, hey, wait a second, there's a law being violated. Why isn't there a lawsuit? We sometimes weigh whether that's the right angle, right?
Yeah, I agree with you. It's a broader strategy in my point of view, because those artists, they also rely on their reputation, the relationship with their public and clients. So it has to be something much more than a law strategy. Of course, we have tools to fight against it, whether in Brazil, whether in the US. And but is this really, really good for their reputation or what people were thinking about them in social media? Everything is about social media right now. So you have to be very smart, because taking those aggressive actions, it has to be serious and it has to be like one shot. Otherwise, you lose a lot. So it's a matter of strategy, in my opinion.
Luísa Sonza, she's getting, I guess she's getting the publicity and, from the viral sharing of this music and video, and I guess that's generating excitement about her as a singer, or maybe awareness about her as a singer. I assume she also does not make any money from this, from these recordings and people downloading or accessing these recordings, performing these recordings. She doesn't get any benefit from that financially, right?
Yeah, but it was not her creation either. So it's something that she got involved by chance, and she's taking advantage as much as she can. That's what I think about her position. So it's better for her to be good in social media than to take actions. That's my point of view.
In the context of something else that's going on in the United States, and this also has a maybe a questionable tie to Brazil, which is we have some recent news regarding trademark registrations by the actor Matthew McConaughey. He has sought trademark registrations and obtained trademark registrations in the United States in relation to recordings of his voice saying, some particular phrases that he is known for. It's kind of interesting to see. Oh, and sorry, the tie to Brazil, right, is I think you told me that he's actually married to a Brazilian. Is that was correct, right?
Yes, she is. Camila, it's her name.
So what Matthew McConaughey did was he registered his trademarks in his voice recording with particular phrases. And I thought that this is interesting in the same context of what happened in Brazil, not because of what he said, because I think a trademark registration for particular words in a recording, it would have to have words that were similar, right? Words that were the same or similar in an infringement action. But what if Matthew could record just the sound of his voice and own a trademark in the sound of his voice without actually saying anything in particular, and then be able to enforce rights based on that sound that someone else has adopted, primarily AI, right? Because that's why it was done as a strategy for AI might imitate his voice and he should be able to stop them. But I don't know of any instances where anybody has registered the timbre of their voice independent of particular words. Could he do that in Brazil? Could Luísa Sonza record her voice and own a trademark in that and enforce that in Brazil?
We don't have sound trademarks. We only have visually perceptive signs that are registered. This is statute. This is the law. So we cannot go beyond that. What we protect the sound of the voice or right of publicity, I think he could get a broader protection of that. And this is constitutional law, so you can get an injunction directly. It's much more efficient than try to comply with the functions of a trademark. I would doubt if there is any function of trademark in, you're mentioning the all right trademark, right? That he filed recently with the USPTO. I think this would be nice to have in order to send cease and desist letters to make it difficult for counterparts to continue the discussion. But in terms of effective measures with the courts, I believe that the personal rights I mentioned previously, would be broader and much better and much more efficient. We like to use the right of publicity as a personal right because it's constitutional. So you have a very powerful tool in courts with that.
This personality right in Brazil, I mean, the way we have it in the United States, rights of publicity is what we call them here, as you mentioned. They are state law rights for the different states, and different states have different rules about them. So one particular rule that's commonly discussed is how long those rights last and who owns those rights. As an example, in California, if someone is a resident of California, after they pass away, those rights persist. But in many other states around the United States, when someone passes away, those rights no longer persist. The other issue is that in some states, you have to have a level of celebrity. You have to have a level of being well known in order to have those rights, and only could assert those rights if you were well known. How is it in Brazil? Do those rights last forever? And does anybody have those rights? If somebody takes my voice and puts it in AI, would I have some action under this constitutional law?
Yes, it's different in Brazil. It's broader, powerful, and since this is constitutional, it belongs to the person who's the owner forever and to his heirs. So, for example, Pelé, the image of Pelé, the very, very famous football player, it's still going on for economic rights. So the family is enjoying the right of image, that's what we call, forever. It doesn't expire. There's no statute of limitation, because this is a personal right. This is a unique image that is being used commercially, and only the person or the heirs, or we call it commercial virtues of the image. You can license for a period of time, and then you can recall royalties, and you can perceive money out of that. So it's a commercial contract. And since this is very powerful, this is civil law, though. This is why it's valid for the whole Brazilian territory, and it could be filed as a trademark only with the authorization of the owner.
It's the image of the person could be filed as a trademark?
Yes. There is a very successful chain of licensing for the pilot Formula One driver, Ayrton Senna. So he licenses his image like until today. So 30 years after his death, the family is still enjoying those personal rights belonging to him. He's so famous in Brazil that he still sells a lot of products. Maradona in Argentina is doing the same thing. Pelé has been doing that even before his death, and many other people.
You said they can go and register as a trademark, but you also said that these personality rights are quite strong, and so they don't necessarily need to do that because of their breadth and scope.
In some cases, it's very convenient to do it. The case of designers, for example. Can you imagine Yves Saint Laurent without a trademark? The origin of the product or the creation was from the creator, the designer himself. But if he wants to create like a very big business like he did, and all the French or foreign designers, they usually transform his image or name into trademarks so they could be part of broader corporate groups, licensed for other means other than the image itself or the name itself.
When you're dealing with personality rights, you cannot transfer them to a business or to someone other than the individual who has those rights?
Other than the trademark, usually no, because you cannot sell your image. No one is allowed to, but you can license for a period of time. But if it is a trademark, it is a property. So you transform your image or name into a property, and then the property could be assigned, licensed, or make part of a bigger business.
That's very interesting. So since you can't do that with a sound, with the sound of someone's voice or a recording of someone's voice saying something in particular, as we were talking about in the Matthew McConaughey example, you can't get the trademark. You only can rely on the individual's personality rights, which are strong, but you can't transfer those and put them into a business independently of that person. Is that correct?
Actually, in this case, this specific example, I would doubt that there is a trademark function. But if there is a trademark function in the expression, I think you can get a trademark. Not that you can't. You can all right is a trademark. It would be registered. I wouldn't doubt that the PTO would not grant the registration. But if it's challenged as the use of a trademark, I would then say probably Michael would not have the function of the trademark necessarily for him to prove that it is really a trademark or of a service or a trademark of a product.
For purposes of the audience understanding that, when you're saying the trademark function, you're talking about the connection that a consumer makes between what is claimed as the trademark and the product or the service that's being offered, right? And so we purchase something relying on that name, that word, that whatever it is. I want to get a clarification from you because you said it might be possible for Matthew McConaughey to register that in Brazil. I want to make sure I understood what he could register. Maybe he could register all right, the 3 words, but he could not register a recording of his voice saying all right, correct?
Exactly. That's the point.
He's had in the United States, all right, the 3 words registered as a trademark for several years. The new registration is his voice recording of that. And so to be able to rely on that voice recording, assuming that there's a trademark use, like you were talking about, some association with a good or a product or service, right? Then the idea would be to use that to enforce against AI duplication of his voice in providing an entertainment service, as an example, which we wouldn't be able to do in Brazil.
With a trademark such as this one you mentioned, we won't have a trademark right here. But we would have other rights, of course. We would have like copyright associated with this piece of work. We would like have another bundle of rights playing together to get the same result, but not trademark.
So let's back up a second. And we were talking a little bit about the platforms. And we had said we haven't been able to identify what platform was used to create this AI song. But we know about a few examples of ones. And I guess the question is, do you think that if there was a lawsuit by Taylor Swift or by Luísa Sonza, if there was a lawsuit under whatever grounds, copyrights, rights of personality, trademarks, if they existed, would a lawsuit against the platform make sense? Should the platforms be liable for the AI production of a imitation of a song?
Generally speaking, I would say yes. Because the platform is promoting the copyright infringement. So probably the platform is not aware that an infringement is going on, because the checks that you declare you're not infringing, so they're protected in the first place. But then if he gets a notification or anyway, if the platform knows that there is an infringement and doesn't take action, so I think then they are responsible. That's what I think. But if they receive a notice that please take down this content because it's infringing my rights, and so they have to take down the content. That's my opinion. So the obligation arises when they are notified or aware of a specific case, such as this one. I think it's a classic. Take it, cease and desist letter. That's what I think. Not different from the cases we have been handling in the past.
Let's differentiate, though, between a platform that makes the song or the video available for users to listen to or watch, and the platforms that are used to create the song or the video. So if we're talking about the platform that's used to create it, presumably they would not be aware at the time of creation of this. And by the time they received some sort of notice, their platform would be done. They would already have accomplished. There's nothing to take down. I don't think you're suggesting that they would have some obligation to go and be the ones to have it taken down and off of other platforms. Am I reading you correctly?
I think it's going to be difficult for them, although we know that they have tools to know if, like, an artist such as Taylor Swift, she's so large and so famous, her musics are so famous, they could have algorithms to detect that. I'm not really a specialist in saying or affirming that, but I would imagine that they would have tools for that. But there are also ways of bypassing those rules. So, for example, the lyrics in Portuguese might not be automatically detected by the platform. So they Google Translate the song, The Fate of Ophelia. Then they just feed with the prompts and say, please create a pagode style or Brazilian hit based on this. This is a Google translation. It's not Taylor Swift's original song. It's a it's a text. So I think this might be like a flaw in the system or something that doesn't detect all the languages that could be possible. It could be in another language. Could be in languages that we don't even recognize the original lyrics. Because Portuguese is very similar to Spanish, so you could like detect Ophelia, Ophelia, so the words are the same. There are ways of doing that. In Suno, there is also a possibility of using the creation of music. So you use a previously existent song and recreate that. It doesn't mean that you are going to earn money with that, but you can play with that. So the platform offers a possibility of, it's getting easier, Matthew, to use copyrighted songs.
I tried it this weekend on Sonos, and what I did was I tried to write an original song using Sonos, but I asked for it to be in the style of a particular artist, like Taylor Swift. And it would not allow me to do that when I mentioned Taylor Swift in it. And I think also, like, even where it allows me to do a cover and it wants me to share what the song is, it does have some protections there. And I guess the question is, would the law require them to have more protections or stronger protections against minor modifications in a song in order to capture that? How much is putting too much of a burden on the technology to filter through and identify that this was a Google translated version of the lyrics to the Fate of Ophelia? My hunch, at least from a U.S. law perspective, is that the courts would not impose that much of a requirement prospectively on a platform that's used to create these things. At the same time, then there's easy workarounds for anybody who wants to do it.
Yeah, you're right. I think the technology is so advanced and we are facing so many things at once that we have to deal with the traditional regulation we have. And what we have is enough. For example, unauthorized reproduction, adaptation, public distribution. So protected musical elements such as melody, harmony, lyrics. So all constitute infringement, regardless of profit, means, or motives. So what I'll say is that copyright law, at least in my country, is enough, is sufficient to cover all that. And what they did was an adaptation of a protected song. And this is why this is not allowed. This is an infringement.
Sometimes in our country, when we have alleged copyright infringements, there's a defense, that like the common ones are like, it's a parody, right? Yes, it was based off of the original, but somehow it's transformed the way in which it's taken right in the public. I think in this case, it's obviously the same song, even though the style is different. The melody is the same. The chord changes are basically the same. The lyrics are the same, except translated. Like Taylor Swift would never never have done a version of the song like this. And like I said, it's really good. And I mean, this is a trademark view, but as a consumer, no one's listening to this song going, this is Luísa Sonza's song. She wrote it. She, I think we all know, I suspect that the Brazilians who've gotten into the song know that this is the Taylor Swift song, but just like this version better, which, okay. So I wonder, is there some sort of aspect in the law in Brazil about how you transform the work if you change it enough so that maybe it would be recognized as its own piece of art that's far enough afield from the thing that Taylor Swift should be able to protect?
You're talking about fair use, right? I don't think we could use that in Brazil. We follow the Berne Convention rule, so we have the 3-step rule. And in this case, I wouldn't find it a parody. It could be a parody, but I think someone has economic gains on that. So YouTube is paying. Spotify was paying, and all the DJs that are playing this same song are earning money. So I don't think it's just a piece of art for as a parody concept. That's my opinion, okay? And also, it's a question of using a voice that resembles Luísa and Dilsinho would be a parody too. It raises a lot of questions. I don't think it could be fair use or three-step rule of Berne Convention. We don't have fair use, just for you to know. We follow the Berne Convention. That's what we do. So it's kind of difficult.
Is there anything that you can do to stop something like this that's after the fact, that's gone viral and everybody knows about it and it's out there? Is there anything that the author of the song, the original recording artists or the artist who it's being attributed to can do after the fact?
She has to notify all the platforms. It's like a whack-a-mole game, but it is necessary because it's not going to be the first time. It's her work. And according to our law, she has moral rights. She has the right to define who's going to play her song or adapt her song the way she wants. So this is why, although the music is very nice, it's very fun, and the rhythm is nicer, or for our culture, for example, I don't think it's correct. It's an infringement. So I'm biased here.
That's fair enough. And I guess she could go down and start taking it down. She has taken it down off of many platforms, even if it wasn't off of YouTube yet. But I think you mentioned something else to me when we were talking about this over the weekend, which is this is not the only recording, the only version of this song in Portuguese that is out there. Can you tell us a little bit about what you know?
It's so easy to create those songs and to bypass the original tracks or the rules that it's we have found many versions of that. So, and not only Taylor Swift songs, you have anything, you can create anything out of that. So the platforms are now like kind of easy to bypass because you create whatever you want with AI. So if you know how to deal with those platforms, with those tools, you get like excellent things and adapt it to a certain culture. Maybe Taylor Swift thinks it's terrible. It's a terrible song because it's not her style, not her culture. It's not whatever she created because she has the soul associated with the music. So when she sees something that it's not associated with her soul and the way of and why she created this for her public, she thinks it's a terrible thing that was made out of her creation. So this is relative. It's not black and white. We have to think a little bit. So Taylor Swift might think it's a terrible thing.
Yeah, I mean, the fan in me just, I really like that new version, but I get it. I get it from the legal perspective. I think I have one last question for you. It's going to kind of put you on the spot, but we'll see what you think. You can decline if you don't want to answer. But and I think I know what your answer is going to be if you do answer. Under these circumstances, right? You have an amazing firm in Brazil that handles intellectual property matters all the time. You've helped me, and I know you've helped many other U.S. companies, and as well as ones in Brazil and elsewhere. So your firm is called Matthew Murad. And my question to you is this: as one of the principals of Matthew Murad, who would you want to represent in a proceeding involving something like this? Would it be Taylor Swift? Would it be Luísa Sonza? Would it be the AI platform that was used to create the work? Would it be the AI platform? Would it be the platforms that are used to present the work? Or would it be the creator of the work, whoever used those platforms? Who would you want to represent?
Okay, none of them are my client, okay? So they have different rights. So they're legitimate to file like Luísa Sonza, image and voice, not image, but personal rights and voice. This Dilsinho also. She has not the same rights as Taylor. Taylor is the owner of the song or the producer or the record company. So there's another stakeholder on that. And also on the other side, the platform. So it's a very difficult question. We would have to recreate fair use. I think it's much easier to represent Taylor Swift and Luísa because we're attacking, and it's not a question that the work of art was infringed and the voice was infringed. So it's much easier. But if you want me to think out of the box, you know, then I would like to represent the platform. But anyway, generally speaking, I would like to move forward with the law. Sorry not to answer directly, but I would like that the law be resolved. It has to be clear to us in the society as a whole what to do and not to do. So, being the platform lawyer would be very interesting from this point of view too.
I love your answer. I think it's a great answer. It was a lawyerly, it depends answer, which is always good.
We have to change the way of thinking. Since you mentioned fair use, what is the extent of fair use in civil law countries? Interesting, right? Since we don't have fair use, the way the U.S. attorneys think.
Based on our conversation, if I could change the Brazilian law, I would change the trademark law to allow you to record not only a recording of a voice as a trademark, but the timbre of the voice only without regard to the words being spoken. But I would do that in the United States too. Not that the United States law says that you can't do that, but I don't know of anyone who's done it. So I would think that we should find a way to be able to register trademarks in the timbre of a voice to protect artists like Luísa Sonza, who I'm now a fan of as a result of this AI-generated copy. I never heard of until then. Anyway, that's what I would want to do. I do think that the infringement is fairly obvious here, but the problem is, tracking down the infringers and what the economic benefits will be of doing it in a lawsuit. That said, my guest has been Flavia Murad-Schaal, my friend and an amazing attorney in Brazil, principal of Mansur Murad, and we're really glad you could be here today. Thanks so much.
Thank you so much, Matthew. It's a pleasure.